In 1971, several men embarked on a multi-year enterprise to import marijuana from Colombia to Florida. This project involved a good deal of telephone and in-person communication, buying and sailing around in boats, driving marijuana around in rental trailers, and meeting in motels to demand payment. Eventually, the government arrested 7 defendants. Their trial, United States versus Johnson, raised the rather unusual question of whether years of smoking dope amounted to an expert qualification. At trial in federal district court, the government had to prove that the marijuana came from outside the customs territory of the United States. The government's principal witness was John de Pianelli. In addition to providing a detailed account of the drug smuggling operation, de Pianelli testified as an expert on the origin of the marijuana. De Pianelli acknowledged that he had no special training or education in identifying marijuana, but that he had developed qualifications from, quote, the experience of being around a great deal and smoking it, unquote. On voir dire and cross-examination, de Pianelli stated that he'd smoked marijuana at least 1,000 times and dealt in it at least 20 times. He testified as to his skill in identifying marijuana based on its leaves, buds, and stems, and the smell and effect of its smoke. He could identify the source of marijuana based on its appearance, packaging, smell, taste, and effect. He'd identified marijuana over 100 times and never made a mistake. In his experience, he found that Colombian marijuana grown in the United States was different from Colombian marijuana grown in Colombia. The court permitted de Pianelli to give opinion evidence. De Pianelli told the jury that he'd tested samples of each of the shipments in this transaction and had verified that they were indeed from Colombia. 6 of the defendants were found guilty of conspiracy to import marijuana. They all appealed to the United States Court of Appeals for the Fifth Circuit.